Today's lecture will continue with legal and ethical issues. Preventing malpractice claims. Lawsuits add to the cost of healthcare and take a psychological toll on all involved. Risk management is able to identify and track possible issues and develop improvement plans. Once the plans are in place, they will be monitored and reassessed for effectiveness. Medical negligence. Medical negligence cases are those in which a person believes that a medical professional did not perform an essential action or performed an improper one, thus causing harm to the patient. Postoperative complications. For example, a patient starts to show signs of internal bleeding. The incision is reopened and it is found that the surgeon did not completely cauterize all severed capillaries. Res ipsa loquitur. The thing speaks for itself. This refers to a case where fault is obvious. For example, a surgical instrument is accidentally left inside a patient. Abandonment, stopping care without qualified substitute. For example, leaving a woman in labor because your shift has ended but your replacement is running late and there is nobody else available to cover. This would constitute abandonment. If a practitioner is going to be absent for a period of time, they may hire a locum tenens or a placeholder as a substitute in their absence. And delayed treatment. If a doctor decides to delay treatment of illness symptoms or a disorder, and the delay causes the patient direct harm, the patient may have a case for negligence. Malfeasance, unlawful act or misconduct. Misfeasance, lawful act but done incorrectly. Nonfeasance, failure to perform an act as required by duty or required by law. Please know these three words and their definitions. Please note the 4 Ds of negligence and the definitions. Duty. Patient must show that the physician-patient relationship existed in which the physician owed the patient a duty. Derelict. Patients must show that the physician failed to comply with the standards of the profession. Direct cause. Patient must show that the damages were a direct cause of a physician's breach of duty. Damages. Patients must prove they suffered injury. Malpractice and civil law. Malpractice lawsuits are part of civil law, coming under the heading of torts. Settling malpractice suits. Trial is a court system that decides the outcome of the case. Arbitration is the use of a person outside of the court system. A deposition may be required. This is a sworn statement of facts of the case. A subpoena, a written court order for attendance. A subpoena testificandum is required to provide testimony under penalty. A subpoena ducis tecum, court order to produce specific requested documents required at a certain place and time to enter into court records. The law of agency. According to the law of agency, employees are agents of the physician when performing professional tasks. Respondeat superior, let the master answer, is used to describe this relationship. Physicians are liable for negligence of their staff. The American Association of Medical Assistants offers medical assisting malpractice insurance through various insurance companies at reduced rates. Courtroom conduct. Attend proceedings as required. Bring required documents. Refresh your memory before testifying. Speak slowly, clearly, and professionally. Answer all questions and only questions asked, and appear well-groomed with conservative clothing. Malpractice insurance protects physician and staff from financial loss. It's a high cost to the practice, as high as $200,000 a year, depending on the type of practice. And it is necessary because of greedy, litigious society. Reasons why people sue. Unrealistic patient expectations. Poor rapport and communication may translate to poor quality of care. Statute of limitations. Laws that set deadlines or maximum time within which a lawsuit or claim may be filed. Most common length of time is 2 years and varies on the circumstances and type of case and claim. The periods of time can vary from state to state and whether the case is filed in federal or state court. Medical, usually 1 to 4 years from the act of occurrence of injury or 6 months to 3 years from discovery. Certain circumstances can extend the period, such as if the party is a minor or in cases of fraud. Legal, 1 to 3 years from date of discovery, or a maximum of 2 to 5 years from the date of the wrongful act. The 4 C's of medical malpractice prevention. Please learn these. Caring. Most important asset is showing your patient that you care. Communication. Communicate professionally and check understanding. Competence. Be competent and maintain and update your knowledge and skills frequently through continuing education. Charting. Documentation is proof of competence. Chart everything timely and accurately and have entries reviewed by the physician. And this is done quite easily now with the electronic medical record. Effective communication can help prevent lawsuits. Make sure you have good listening skills. Help patients feel comfortable. Dedicated time to return patient calls. Informed consent forms are explained and signed. Avoid statements admitting fault of physician or staff. Use tact, good judgment, and professionalism. And explain fees before treatment if that is your responsibility. And that ends this lecture for today.